welcome back to CLAT, and today we will be having a detailed discussion on the recent landmark judgment of the Supreme Court on sub-categorization of the scheduled castes and scheduled tribe groups in India. Let's first delve into the actions of the Punjab government before going into the judgment itself. The Punjab government in 2006 introduced a legislation called the Punjab Scheduled Castes and Backward Class Reservation in Services Act of 2006. What this legislation essentially did was that it provided specific reservation for two groups, namely the Balmikis and the Mazhabi Sikhs under the ambit of scheduled castes. It was noticed that even though scheduled caste reservation was provided for employment and education, still Balmikis and Mazhabis did not essentially receive the benefit of reservation. That was because the reservations were consistently taken up by other scheduled caste groups, and therefore the Balmikis and Mazhabi Sikh groups did not receive any sort of social upliftment. To solve this problem, what the Punjab government had decided to do was provide specific reservation under the ambit of scheduled castes. For example, if scheduled castes were to receive 15 seats out of 100, 5 seats out of the 15 could be reserved specifically for people belonging to Balmiki or Mazhabi groups. However, the same was challenged in the High Court. So let's proceed to the judicial history of this judgment. A particular litigant by the name of Davinder Singh filed a case in the High Court of Punjab and Haryana against the legislation passed by the state government. However, the High Court relied on a Supreme Court judgment which had come out only 2 years prior, that is, in the year 2004. This judgment was the E.V. Chinnaya versus State of Andhra Pradesh judgment. This related to a very similar instance where the government of Andhra Pradesh had provided specific legislation to groups under the ambit of scheduled caste reservations. However, the Supreme Court in this case had held that scheduled castes and by extension scheduled tribes are homogeneous groups. That is, they do not have any separate identity within this group itself. Therefore, specific reservations under the ambit of scheduled castes and scheduled tribes cannot be provided by state governments. The High Court of Punjab and Haryana relied on this Supreme Court judgment to hold that the legislation passed by the state of Punjab was therefore invalid. However, there was an appeal process started by the state government which finally culminated in 2020 when the matter was taken up by the Supreme Court. However, the Supreme Court had referred this judgment to a 7-judge bench in the case of Davinder Singh versus State of Punjab, so that the previous judgment of a 5-judge bench, which was E.V. Chinnaya versus State of Andhra Pradesh, does not act as a prohibition for them to change the position of law. In 2024, the most recent judgment of Davinder Singh versus State of Punjab came in with the 6:1 majority, and the Supreme Court held that scheduled castes and scheduled tribes were not homogeneous groups. They had separate identities within the groups itself, and therefore, if the state government deemed it fit, they can specifically provide reservation for subgroups of scheduled castes and scheduled tribes within the total reservation quota that is provided to SCs and STs. Now let's move on to the present judgment at hand. The rationale for holding that scheduled castes and scheduled tribes were not homogeneous groups is that there are differential requirements that subgroups may have within the scheduled tribes and scheduled castes itself. Furthermore, there are instances where people belonging to SCs and STs have taken the benefits of reservation generation after generation. Therefore, there are certain minority SC and ST groups who have never been given the benefits of reservation. To solve this problem, Supreme Court took a twofold method. Firstly, they held that even if state governments are allowed to make reservation for subgroups within SCs and STs, this reservation should still be proportionate to the population of the subgroups. Let's say Balmikis and Mazhabi Sikhs in Punjab form 2% of the population of Punjab. Therefore, within the 15% scheduled caste reservation, they should still be provided only 2% reservation, which is in proportion to their population as a whole. So this proportionate representation was something that the Supreme Court was emphasizing on. It further laid down that in no case can 100% of the scheduled caste reservation be provided to specific subgroups. That is, if 15 seats are reserved for scheduled castes in Punjab, in any case, all 15 seats cannot be reserved for the Balmikis and Mazhabi Sikhs. Proceeding with this, Supreme Court also laid down the concept of first generation reservation. They said that the rationale for providing reservation under the Constitution was that once you have received the benefit of reservation, you will be at an equal playing field with the rest of the population. And once you have received the same equal playing field, you do not need the benefit of reservation anymore. Therefore, the future generations of a family that has already undertaken the benefit of reservation would not require the same benefit anymore. The second important aspect of this landmark judgment is the application of the creamy layer principle. As we all know, Mandal Commission way back in 1978 determined the formation of the other backward classes. Later on in 1992, Indra Sawhney versus Union of India was a landmark judgment that laid down two major principles. Firstly, it held that the total percentage of reservation in India cannot exceed 50% of available seats. But the second, more important aspect was the application of the creamy layer principle to the other backward classes. The creamy layer principle essentially meant that if a person within other backward classes fulfills certain economic criteria, that is, they have income of more than a certain amount, then they would not be provided benefits of reservation under the OBC category. This creamy layer principle was only applicable to other backward classes until 2024, when in Davinder Singh versus State of Punjab, the 7-judge bench of Supreme Court held that this creamy layer principle should now also be extended to scheduled castes and scheduled tribes. That is, if people within these reservation classes have income over a particular standard set by the government, then they would not be able to avail the benefit of reservation. Overall, this judgment marks a very important step in the reservation history of India, and it marks a step in progress where people who have received benefit of reservations should not be given the benefit again because they already have the equal playing field. Finally, more deserving people, that is people who have not yet received the benefits of reservation, can be provided specific reservation under the ambit of scheduled caste and scheduled tribes as a whole. Hope this clarifies the landmark judgment on sub-categorization of scheduled caste and scheduled tribes. I'll see you again in the next video. Thank you.